Welcome back to Hannity. So with just 11 days to go until the New York Democratic primary, Senator Bernie Sanders, Hillary Clinton, they're fighting for every delegate in the Empire State. But Hillary has more than just a few delegates to worry about. There's still that ongoing Comey investigation at the FBI over the server scandal. But during an interview with Matt Lauer earlier today, she didn't seem too concerned. She was yucking it up and laughing. Take a look.
They say this, that they will get to see Hillary Clinton in handcuffs.
Oh, my
That there will
goodness.
be some kind of political perp walk based on your private email server.
Well, Matt, I know that they live in that world of fantasy and hope because they've got a mess on their hands on the Republican side. That is not going to happen. There is not even the remotest chance that it's going to happen. I think it's a security review. It is a security review, and there are lots of those that are conducted in our government all the time.
Here with reaction, the chief counsel for the American Center for Law and Justice, Jay Sekulow, criminal defense attorney, former prosecutor, our good friend Robert Bianchi is with us. All right, Jay, let's start with you. You know,
yes,
she can yuck it up and laugh all she wants. I can't imagine dozens and dozens of FBI agents have spent months on something. Oh, this is nothing. This is no big deal. You know, she's not going to be led away in handcuffs. I don't think I'd be feeling that way if I was her.
Well, you know, she keeps calling it, and the media, some of the media is doing this as well. They keep calling this, Sean, a security review. I was a government lawyer in the beginning of my career, and this idea that this is a security review, well, then it would have been conducted by the Inspector General's office of the State Department. This is not that. This is the FBI with numerous agents involved, reviewing all of the information to determine, in fact, if there's been a violation of criminal law. And this comes on the heels of, in the last 5 weeks, 2 federal court judges, one calling her setup extraordinary, another chastising the government for allowing this whole setup to begin in the first place, and of course accusing the government of cover-up. So this idea that this is just some, nonchalant security review that happens in every government agency, the FBI does not usually engage in non-departmental security reviews. That would be handled by the Inspector General's office. So there's a lot more to this. The question will be, will the Department of Justice take the advice, if the FBI makes a determination, if they make the determination and do what's called a CRL, a criminal reference letter saying, here's the case to the Department of Justice, laying it on the table, so to speak, will the Department of Justice take action? That becomes the political question.
Well, that becomes the big scandal. Robert, do you see a criminal referral coming out of this based on what we know now from the Inspector General of the intelligence community? Dozens and dozens of these emails beyond top secret classification, special access program classification. Seems to me that the law was broken.
Well, Sean, I've said this from the beginning of this case. The procedures and policies with regard to how these emails are allowed to move have not caught up with the modern times with regard to the technology and old laws. They're going to have to show that she knowingly, in my opinion, was violating the laws, because as a former head prosecutor, we are not dancing on a pin on technicalities.
Well, I do have some evidence that she knew, because she actually sent out a memo to the entire State Department warning them against the use of emails, in other words, work emails on private devices.
Yeah, but Sean, what people don't understand as far as what the U.S. attorneys do and what the FBI does is they want rock-solid cases they can prove to 12 folks beyond a reasonable doubt. And there's a lot of very subjective language in these statutes. For example, a case in 1941 indicated that even if you violate the Espionage Act, you have to show it was done with the intent to harm the interests of the United States.
But that's not the standard. Isn't the standard also...
Well, how about the moving of the...
Go ahead.
How about moving the server to a private location? I mean, that's the basic claim where this all started, that the server itself, her personal server, where these emails came that were top secret and special access, were actually moved to a private, non-governmental, non-approved, not secured server in Colorado. That in and of itself, and listen, I had to try cases too as a government lawyer, and I don't disagree with Robert. You can't do it on mere hope. You've got to have evidence. But that, to me, we should not lose sight of the fact, not only was it the emails, but it was the server itself. Yeah.
And gross, in other words, the handling of it, if that was, in other words, if they mishandled such sensitive information, isn't that a crime in and of itself, Jay?
Yeah, and I think what's happening is everybody's getting caught up in the individual emails, which, believe me, are problematic, and obviously if they're beyond top secret, where Congress can't even have access to them, or, as you mentioned, the special access emails, that's problematic. Those are all parts of a crime. Now, I don't disagree with Robert because I had to do this. When you've got to prove your case in court beyond a reasonable doubt, I mean, that's a tough standard. But the reality is the FBI, I don't believe, and Robert probably doesn't either, believe that this is simply a security review.
All right, well, let me ask
I
Robert
think
this.
that's beyond the pale here.
Why did they give Pagliano, a guy who pled the Fifth, immunity now?
They're giving him immunity because he exercised his right to remain silent on the Fifth Amendment, and they may want his testimony not only to maybe seek a conviction or evidence to further the investigation, but also to exonerate. I did that plenty of times when somebody had relevant information and they were able to assert the Fifth Amendment. You have to be careful here because the FBI and the U.S. Attorney's Office is not going to be prosecuting a case with fuzzy language and facts, especially when there's been a custom and practice of using private servers and private emails before. And those people
that is not exactly accurate. I know that's the Democratic talking point.
Right.
It's not accurate because nobody went to the length and the depth that Hillary Clinton did. She put her server in a mom and pop shop. It ended up in a bathroom closet.
Agreed.
And we're talking about top secret information where American methods and names of people and operatives could be compromised and maybe end up getting killed.
I don't disagree with that, Sean, but you're right. It is different because she had her own server. The other people were using things like Yahoo and Gmail that are going outside the
Which was
United
actually
States.
she did.
Actually safer. The reality is 18 U.S.C. Section 1924, and this is where there's not fuzz. This isn't fuzzy. Says if you knowingly and willfully put the material in an unauthorized location, it is a crime, punishable by 1 year imprisonment and $10,000 or both. That is 18-1924. That's the criminal code. So the question, I go back to the server issue. That's different than the way anybody else set this up, and an occasional use of a personal email account is one thing. An intentional act, and this is where the government would have to meet its burden, an intentional act to set up the server to circumvent the safeguards that are in place within the State Department, that's the problem for Hillary Clinton. Now, again, the political question will be, will they indict? But I don't believe that, by the way, and Robert may know more about this particular case than I do, I don't think they gave immunity because they think it's going to exonerate anybody. It may not just be Hillary Clinton, by the way. It may be other people that they're targeting here. We don't know that.
And I agree with that, too. And the statute that you just read is the right statute, but it also says with the intent, which means it was her speech.
Yes,
they have to prove. And you know, counsel, as well as I do, how difficult it is to prove intent without some direct evidence.
Yeah.
Now, maybe they gave immunity to this guy because he has that direct evidence. But right now, I think this is going to be a very difficult case for the government to prove. And the FBI and the U.S. Attorney's Office does not like going into courtroom with cases that talk about intent when there's policies and procedures that have gone on for many years where this whole thing has been very fuzzy.
But, Robert, the thing is, this doesn't go, I don't think it goes, this is not the typical case where it's going to go from FBI to DOJ right to a U.S. attorney. There's a lot more politics involved here. It goes from the FBI to DOJ, and there's a thought process there.
Do you think that criminal referral happens, Jay? Yes or no?
I think it's, you know, look, I think that the risk for Hillary Clinton is great, but the reality is indicting the former Secretary of State would be a big step. The president would basically, through the Justice Department, would have to authorize it.
Does the FBI
he received some of those emails.
Is there a criminal referral by the FBI?
I would not be surprised at all if there's a recommendation on a criminal referral.
I've said this, I said it before, I say it right now.
I don't know if it goes to Hillary Clinton, but yeah.
There will not be a referral on the substantive allegations unless, during the course of the investigation, there was an attempt to obstruct justice by hiding something. And if there is, then there is a referral.
My guess is, knowing the Clintons, that happened. All right, thank you both. Coming up next tonight.